I've got 5 minutes to talk about social media, so what I've tried to do is draw together a couple of key themes that I've seen in recent cases from the point of view of defamation and privacy law. And I thought I would start off first of all with some figures, and just to build on what Mark was saying about cyber risk. There's some pretty startling figures there. The key one being the suite of Maxwell. I'm afraid I couldn't get anything more up to date than their figures as of 2011. But the number of libel claims, people always think of libel as traditionally claims brought by celebs against the media. But no, what we're seeing more and more is it's claims brought by companies or against companies, and that the number of libel claims involving social media as of 2011 has more than doubled. I think we're seeing a growing trend involving social media, and you only have to look at the recent cases to see that even if it's involving mainstream media, there is also some sort of social media element to them, which I will come on to in just a minute. So first things first, a lot of people think that they can hide behind anonymity, and that is possibly the nature of the beast and the problem with social media. But newsflash, that is not the case at all. The first case that I've mentioned there is Brooks versus Facebook. That is a Norwich Pharmacal order that was obtained last year. Norwich Pharmacal order being an order that, in this case, Facebook has to provide Ms. Brooks, who was being bullied on Facebook anonymously, with the IP addresses of those people who were running the accounts that were bullying her. That's just one instance. There's loads of Norwich Pharmacal orders that are coming through the courts now involving Facebook and Twitter. And you may ask why. That is because Facebook and Twitter, in common with a lot of website operators, have a stated policy that they won't disclose account details unless you've got a court order. They normally do disclose details. What I would say is Mr. Ryan Giggs had a bit of a problem enforcing his Norwich Pharmacal against Twitter 2 years ago when he was named as CTB. And the slight hiccup in that was that he had a Norwich Pharmacal order requesting the details of something like 100,000 Twitter users who had named him as CTB, which might have been the problem. It was more of a practical thing that Twitter just frankly couldn't be bothered to comply with the order of the English courts. But on the whole, they do comply, armed with an English court order requiring them to provide that information. I mentioned the defamation bill at the bottom. I won't dwell on this because it keeps changing, and as you've probably seen, there was a bit of a hiccup in the House of Lords a few weeks ago, and who knows when and if it will ever come into it be enacted. But there is an internet defence. It builds on the existing internet defence, which is already part of the statutory law in this country. But essentially, what the defamation bill intends to do is bring in further statutory provisions to protect a website operator faced with claims for defamation. But one of the key things that's been talked about is that they will only be able to rely on that defence if they provide the claimant with the details of the person that has been defaming them anonymously. So query whether we will see as many Norwich Pharmacal orders in the future. In defamation cases, you have to prove publication. That is your first hurdle. People often assume with the internet that just because it's out there, and in particular in social media context, just because you've got 300 friends or followers, that you can prove publication. That is not correct at all. Just because you've got 300 friends doesn't mean that they're reading your Facebook site. Probably none of them are reading your Facebook site. So the first hurdle is you have got to prove that people have actually read the defamatory statements. A couple of cases there that I've mentioned where the claimants were able to prove publication, but what the courts actually did was take into account the viral effect, a grapevine effect nature of the internet when arriving at the appropriate level of damages. So Cairns and Modi is the first one. Mr. Cairns was accused by Mr. Modi of match fixing. On Twitter, 65 publishes that were proved. It could have obviously been seen by hundreds, thousands more people, but it was agreed on between the experts acting for each party that 65 people had seen it. He was awarded 90 grand, That went to the Court of Appeal in December because Mr Modi said that's far too much. Court of Appeal said no, even though 65 people only did see it, millions more could have, and so that £90,000 was an appropriate award of damages. The second case, Cruddas and Adams, that came out only in January. Mr Cruddas he was the treasurer for the Conservative Party, who Mr Adams had accused of accepting donations in breach of statutory regulations. The allegations on Twitter mirrored those which had been reported in the Sunday Times and the Independent. And the interesting thing about that is that the Independent had already made a public apology when it was found to be untrue, and had made a substantial sum in damages paid to Mr Cruddas. So that was taken into account by the court because the court said he'd already received a certain amount of vindication. But Mr Adams had carried on tweeting even though it had found to be untrue. He had carried on tweeting that Mr Cruddas was a criminal, and had actually egged him on Twitter in order to sue him, which eventually he did because Mr Adams wouldn't shut up. And again, in that case, he was awarded £45,000 in damages, which again goes to show that, and no doubt Sally Burkow will find out soon, that inappropriate tweets can be quite costly. Moving on to privacy and private information, one of the things that I think you need to be aware of is what is being said about you on social media, not just from the point of view of people, your followers, friends are going to see it, but also mainstream media do use it as a valuable resource. I should have said valuable in inverted commas. But one of the cases that I wanted to just mention briefly, and I will apologise to Mr Rock and Roll for missing the N out of his surname, is a case that was decided in January. And Ned Rock and Roll had married Kate Winslet over the Christmas period. NGN had obviously been sniffing around on Facebook to find out what they could about this relatively unknown nephew of Richard Branson. And they found a photo of him, which apparently innocent but embarrassing, they wanted to publish. Ned went off to get an injunction to prevent the Sun from publishing the photo. And the interesting thing about this case was that the photo, it wasn't on Facebook, it wasn't on Ned's Facebook page, it was on one of his friends' Facebook pages. His friend apparently had 1,500 friends, but not only that, due to the change that Facebook introduced a couple of years ago, often resetting people's privacy settings, it could have been open to anyone to discover from the public. But obviously, if you typed into Google Ned Rock and Roll photo, you're probably not going to find it. So in this case, although it was generally accessible by people on Facebook, the court held that there was still something to be gained from Ned obtaining an injunction to prevent the Sun from splashing it all across the front pages. They said although the photo was on Facebook, it was taken in private premises at a private party, he had a reasonable expectation of privacy. So in that sort of situation, the court is obviously concerned with protecting his right to privacy on the one hand and NGN's right, in this case, to freedom of expression. And that's obviously a balancing exercise. And now, one will normally trump the other if there is a public interest. In this case, the court said there was no public interest at all in people seeing Ned in whatever innocent but embarrassing position he was photographed in. That may change depending on the context, and I don't unfortunately have time to go into what is the public interest. But it is something to bear in mind within your organisations. I appreciate probably not many people are in the spotlight, media spotlight, in quite the same way as he is now. But one thing to bear in mind is the extent to which your senior officers are on Facebook, Twitter, doing something which might be inconsistent with the brand and the brand image that could possibly be in the public interest. So just be aware that the media is sniffing about and could potentially discover something that you would rather they didn't. I probably don't have time to go into these slides in too much detail, but...
We've got 2 more minutes, haven't we?
Thank you. But there are some practical considerations here just to sort of take away with you. And I think social media is something that people are investing more time and effort in. going forward. But a couple of things that you can do that are relatively cheap and straightforward to do. There are free tools available, such as Google Alerts, Hootsuite, for monitoring what is on social media. Because it's not just a case of what you're saying that might open you and expose you up to potential claims, but more key is what people are saying about you. And you need to be aware of that so that you can act quickly. One of the things that a lot of people do on Facebook is suck pages, similar to suck sites, and the question is how you deal with that. Ideally, prevention is better than cure. So if you're not on Facebook and potentially you might want to be, then get the names in. You might be surprised that facebook.com/Apple is not owned by Apple. It's owned by an imitation Facebook page. So get in there quick before your competitors or potential people who want to target and defame your brand do. Consider what you want to achieve and how best to achieve it. How are you going to deal with negative comment? Because people aren't probably going to use social media to praise you. They're going to use it to slag you off. So how do you deal with that? Make sure you've got a strategy in place and procedures in place, and that you stick to it. I mean, a lot of people these days have their own corporate Facebook sites. If people leave negative comment on there, what are you going to do? Are you going to take it down? Because it's obviously going to look very one-sided if you only leave up the good stuff and take the bad stuff down. And you're potentially going to open yourself up to more criticism if you do take the negative stuff down. Employees and use of social media. I'm not just thinking about the extent to which they use social media in the workplace, but in terms of your own corporate brands and corporate pages. Are the appropriate people using it? Are they trained? Are they aware of the risks? Again, that sort of comes back to having the policies and procedures in place as to how to manage those risks and try to prevent issues arising in the first place. But then if they do arise, how do you deal with it? One thing to be aware of is that a lot of people use Facebook to slag off experiences that they've had with particular individuals in your company. You might want to think about whether you take that down, not on the basis that it's negative comment, but on the basis that it's private information. And from an employer perspective, you probably don't want your employees' private information and personal data up on Facebook. Finally, I would just say, if you do think that you're going to want to take action, you've got to act fast. It can go viral in moments, so if you want to take something down, you have got to take steps immediately to get that information taken down and preserve the evidence before you contact that third party in case they do take it down, because if you want to sue them for damages, then you obviously need that evidence in place first. And that's all I need to say. The only thing I would say is that there is a seminar on the 27th of March, is it, Emma? That the IP litigation team are doing, where they're going to be talking about social media in a bit more detail and maximising the rewards and talking about some of the potential pitfalls. The details are in your pack, so if you want to sign up for it, then just drop whoever it is an email. And over to questions.
Thanks, Abby. And thanks to all our speakers. We've got about five or 7 minutes for any questions. Has anybody got any questions? Please.
A quick question for Abigail, actually. The enforcing privacy in the UK, I mean, can that be enforced internationally? Is that one of the issues?
It depends on the jurisdiction. I mean, America is a case in point, but it's extremely difficult to enforce an English court order over here that will offend American law. And I think in that situation, because privacy is an area of law that varies so much from one country to the next, and that you would be best to take jurisdiction-specific advice in the particular countries. I mean, case in point, I suppose, is the recent Kate Middleton pictures, where French law traditionally very, very strict on privacy, but yet she was photographed in France by a long lens camera, and yet those pictures were published in various jurisdictions around the world.